Hi, in the final clip for this week, I'd like to cover the crimes, Klabbers refers to them as core crimes, that make up the subject matter jurisdiction of the ICC. But before I get there, let me point out that these are not actually the only crimes that carry the label international crimes. Notably, the crime of piracy, but potentially also the crime of slavery and subjecting someone to torture or inhumane or degrading treatment, are also all crimes that are potentially pursued as international crimes in certain jurisdictions. And this can be quite relevant. Take, for example, the case of piracy, which under the principle of universal jurisdiction, and I think I mentioned this already earlier in this course, can be prosecuted by virtually any state in the world, at least as a matter of principle. And this is the way in which public international law for now centuries has been dealing with the problem of piracy, which, although these acts are usually committed on the high seas, need in fact to be prosecuted somewhere. However, if we look at the core crimes covered by the ICC, we see that they are somewhat different and special in the sense that they are particularly heinous and that they usually involve large-scale violations of human rights that, as it is sometimes said, shake the conscience of mankind. I'd like to begin this overview by looking at the core crime that is probably most easily understood given what we talked about last week, and this is the category of war crimes. War crimes really include any breach of the law of armed conflict as stipulated in the Geneva Conventions and the additional protocols, and that then are established in greater detail in the Rome Statute and in the elements of crime, which basically transpose these state obligations under these instruments that we discussed last week into individual obligations. So, to briefly answer the reading question, if you look at Article 8 of the Rome Statute, you will see a massive overlap with those instruments that I just mentioned, and in general, you will notice that there is a huge interconnection between those two domains of international law. So, the law of armed conflict on one hand and ICL on the other one. One prerequisite, of course, is that there has to have been an armed conflict, and this is reflected in the so-called nexus requirement. Nexus refers in this context to the link between the actions committed allegedly by the individual in question and, on the other hand, the armed conflict, which can be an international armed conflict or a non-international armed conflict. In the case of the latter, of course, we have to find out whether the threshold of a NIAC has been met, so as we discussed last week, whether the conflict is intense enough and whether there has been a sufficiently high level of organization of the opposing party. And only in that case can we speak of a nexus requirement, and only in that case can the individual actually face war crime charges. The second core crime, and we're actually going in reverse order here compared to the organization of the articles in the Rome Statute, is the notion of crimes against humanity. Of course, you will find the specificities, the specific acts that count as such under Article 7 of the Rome Statute, but one way of thinking about crimes against humanity is that they are all those acts that actually do not show a nexus to an armed conflict. So widespread and systematic violations of human rights that occur in peacetime or where at least there is no engagement between warring parties in a sort of armed conflict context. The kinds of human rights violations that fall within this category include killings and torture and inhumane and degrading treatment and forced disappearances, ethnic cleansing. But once again, it is Article 7 of the Rome Statute which details these obligations, these acts and actions that give rise to individual responsibility, as opposed to the international human rights instruments proper, which of course give rise to state responsibility. Two further aspects deserve mention here. First, crimes against humanity target civilian populations, and this makes sense, of course, because if they were targeting combatants, we would actually be within a context of an armed conflict, we would have a nexus, and in such a case, we would actually have to look into war crime charges against the person that has committed, allegedly, the acts in question. Second, there's the mental element, or mens rea, as it is also referred to in criminal law in general. And in the case of crimes against humanity, this threshold is not actually that high because it is already met when there is knowledge. So if you're a political leader or a military commander and you are aware of and willfully blind to the fact that your troops, your soldiers, are potentially committing crimes against humanity, then you yourself can, under the Rome Statute, be held criminally responsible for these very same crimes against humanity. Third, there is the crime of genocide as laid down in Article 6 of the Rome Statute, but also based on the 1948 Genocide Convention, which is the subject of so many ICJ cases these days. The term genocide itself was coined in 1944 by Polish lawyer Raphael Lemkin and based very much on the experience of the Holocaust and in particular on the systematic destruction of Jewish populations, but also Roma and persons with disabilities by the German Nazi regime at the time. The main difference to crimes against humanity is the mental element, the mens rea. So we saw that when it comes to crimes against humanity, this is mere knowledge. But when it comes to genocide, there is the so-called special intent, or dolus specialis, which is reflected in this very famous phrase that really characterizes the crime of genocide, which is namely the intent to destroy in whole or in part a national, ethnic, racial or religious group as such. Apart from the special intent, the other notable characteristic of the crime of genocide is that the number of protected groups is really limited to those mentioned here, to the detriment, for example, of persons with disabilities, despite the historical experience of the Holocaust. And this can be confusing, frustrating perhaps even, but really a textual interpretation does not allow any different, and this is positive international law as it currently stands. Last but not least, and sometimes flying a little bit under the radar compared to the other three core crimes, is the crime of aggression. Back in the Nuremberg trials, where some of the Nazi leaders were prosecuted in the aftermath of World War II, the term used was crimes against peace to designate the same thing, namely that there was a responsibility for having started the war that led to all the casualties in this case. Now, at the 2010 Kampala conference, so quite a bit after the adoption of the Rome Statute and even after its entry into force in 2002, the state parties to the ICC came together to finally discuss and define what constitutes the crime of aggression. And the outcome of these negotiations is Article 8 bis of the Rome Statute, which defines in particular that two requirements need to be met. The first constitutive element is that this is a so-called leadership crime, meaning that it can only be committed by a person who holds the military or political power within a state to launch an attack, to start a war. So we are back here a little bit at the question of the big fish addressed in the second clip. And in the case of the crime of aggression, this is necessarily so because, of course, only very few people within a state hold the authority to engage in such actions and to commit such a crime. Second, Article 8 bis of the Rome Statute connects the notion of the crime of aggression to the UN Charter and specifically to the prohibition of the use of force under Article 2.4. And this is logical. It makes things a little bit easier for us because it means that if a state has actually breached Article 2.4, then their leaders can potentially be held criminally responsible by the ICC if there is jurisdiction over this particular state. Now, this last aspect is quite a major caveat actually, because when it comes to Russia's invasion of Ukraine, for example, the ICC does not have jurisdiction over the crime of aggression because Russia is not a state party to the Rome Statute. So Russia's political leaders, notably President Putin, cannot be prosecuted for the crime of aggression, even though Ukraine accepted the jurisdiction of the court on an ad hoc basis, as we saw in the second clip, and despite the fact that all the other three core crimes can, for that reason, because of the territoriality of Ukraine, its acceptance of the ICC's jurisdiction in this case, be in fact prosecuted. This is not the case when it comes to the crime of aggression. The fact that Article 8 bis refers to the prohibition of the use of force as established in the UN Charter presumably also means that non-international armed conflicts fall outside the purview of this provision. So whether in fact a crime of aggression can be committed within the context of a non-international armed conflict and when that would be the case is still very much an open question. I'd like to end this clip by reiterating the recommendation that I made earlier and that I always make, which is to look at the primary legal source, in this case Articles 6 to 8 of the Rome Statute. And it is particularly important in the context of international criminal law and the ICC because, of course, as criminal proceedings, they need to adhere to the legality principle. So have a look at the provisions, study what is included, what is not included, and bring any question that you might have to class. I look forward to discussing all of this with you then.